Okay, good afternoon, everyone. My name is Jeremy Herman. I am an employment lawyer with Samfiru, Tumarkin, LLP. I'm located in Toronto. It's great to be back with you, hosting another one of these question and answer sessions. I've hosted many of them, and it's always great to get the questions from all of you about your workplace issues, and gives me the opportunity to explain what your workplace rights are. As you know, we have offices across the country. In Ontario, we got our Toronto and Ottawa office. We also have an office in Vancouver, British Columbia, and Calgary, Alberta. So we are all around to help Canadians with your workplace issues and rights. Before I delve into questions, which is really the purpose of this session, I want to also talk about a trending issue right now. And what that is the closing of Hudson Bay stores. Many of you might have heard about this, but we are seeing, first of all, after 350 years in business, Hudson Bay is closing its stores. It's Canada's oldest retailer. So this is a big deal, and it's impacting and will impact many, many employees who are employed there. So we're looking at Hudson Bay stores. We're also looking at Saks off 5th and Saks Fifth Avenue stores. And so they're closing down, and they filed for creditor protection. And so what that means is that employees who are terminated as a result of the stores closing down, it's not that those employees do not have rights to severance. Their rights don't go away, but practically they are not going to really be able to enforce those rights because of this creditor protection. And that is, very unfortunate. And it is the case when a business files for bankruptcy or for creditor protection. However, there are many employees who work within these stores. So, for example, a Hudson Bay store, and the employees may not actually be employed by Hudson Bay. The employees who are employed by Hudson Bay and who are laid off, they're going to have an issue. That's the practical reality. They're going to have an issue collecting their severance. However, there are employees, as I mentioned, who are working within the Hudson Bay stores, but aren't actually Hudson Bay employees. They could be employees of Estee Lauder, of MAC, or other vendors that operate within the Hudson Bay store. And those employees also, it could be that they're going to lose their job, because if the Hudson Bay is closing down, then those vendors are going to pull out from Hudson Bay, and as a result, employees will lose their jobs. But those employees who aren't actually employed by Hudson Bay and rather are employed by other employers, those employees will be owed severance because those other employers have not filed for creditor protection. And so those employees are like any other employee in Ontario who is let go and who is owed severance pay. So don't assume that just because you work within Hudson Bay that you're not going to be owed your severance. It really depends on who your employer is. And the way you know that is by looking at some key documentation, including your T4 statements, your pay stubs, your employment contract. All of these kinds of documentation should indicate who your real employer is. And so if you feel or think that you are you're being terminated and you are not going to be owed your severance pay, well, that may not be true, and we might be able to help you. Okay, so you can find out more about this at employmentlawyer.ca. We have resources on this topic, and we'd be happy to speak with you at help. You can contact us at help@employmentlawyer.ca, as you see on the screen, and we'd be happy to arrange a consultation with you. So just very important, something to keep in mind. Let us now delve into questions. Again, if you're joining, my name is Jeremy Herman. I'm an employment lawyer at Samfiru, Tumarkin, LLP. I'm located in Toronto, and I'm here to answer all of your employment questions. So don't be shy. Provide your questions, and I will get to as many of them as I can. So we already have a few coming in. Let's start off with this. We have a question from Fab Chemist 44 on YouTube. My employer laid me off yesterday. We've had a lot of problems with supply due to the issues with the U.S. I presume you're talking about the tariffs. I wasn't given any indication of when I will return. How long can I be kept on a layoff? Okay. So first of all, even if you're laid off or terminated as a result of the tariffs, that doesn't mean you're not owed severance. And I might speak a little bit more about this in detail later in this session. But like I said, you can challenge the layoff right away, because that doesn't mean that it's allowed. Just because your employer might be going through a difficult time as a result of the tariffs doesn't change the fact that you have your employment rights. And typically your employment right is not to be laid off or not to be terminated. And when I say layoff, I mean a temporary layoff, right? An employer is not allowed to just temporarily lay off an employee, just like they're not allowed to they're not allowed to terminate an employee without giving them severance. So if you are laid off, you can challenge that right away. You don't have to wait a certain amount of time to challenge the layoff. That is a termination of your employment. Okay, and you're going to be owed the same severance pay as if you'd been terminated permanently. Now, there is an exception to that, a couple exceptions. One is, what does your employment contract say? So when I have someone come to me, which I do very regularly, and tell me that they were temporarily laid off, the first thing I do is look at the employment contract, if the employee has an employment contract, because that employment contract will indicate whether or not a temporary layoff is legal. If the employment contract that you signed when you started employment with the company says that the employer can lay you off temporarily, then they can lay you off temporarily for a certain amount of time. And that could be, in Ontario, it's usually up to 35 weeks. Could be less, depending on the scenario. But the employer would be permitted to lay you off temporarily in that situation. Okay, so that's one exception. If your employment contract says a layoff is permitted, it's permitted. You agree to it if you signed that contract. However, we have another exception as well, and that is really, has there been a history of layoffs, right? Are you an employee who's regularly laid off? Even if your employment contract doesn't address temporary layoffs. If you have been laid off by your employer before, certainly several times, then it's going to be difficult for you to now challenge another layoff because you've agreed to it in the past. You may not have said you agreed to it, but if your employer has done it and you didn't challenge it, then the employer will argue that you condoned that layoff and your rights are more limited in that case. But if those exceptions don't apply, then yes, you are not allowed to be temporarily laid off and you're going to be owed your severance pay, and you should contact us immediately if you've been laid off. And like I said, the first thing we'll do is we'll look at your employment contract. Then we'll discuss with you what history, if any, exists with regard to a layoff. So I hope that answers your question. And if you have a follow-up, please post it in the chat. Okay. We got another question on YouTube from Letterhead. I joined my company in May 2024 and am now leaving. Technically, I was supposed to give 2 weeks notice, but my boss has lost his temper multiple times, and there have been ongoing pay discrepancies, especially with overtime. Now the employer is saying I won't get my vacation pay because I haven't completed a full year or because I'm not giving 2 weeks notice. Am I actually entitled to vacation pay? Can the employer legally withhold it? So, few things going on here. One, you're talking about a resignation or quit. So if you're quitting from your job, yes, you are supposed to give your employer notice. Usually the amount of notice that your employer wants to receive is outlined in the employment contract. If you haven't given that notice, technically you've breached the contract. If your contract says that you are supposed to give 2 weeks notice and you don't, and you say I'm resigning effective today, then you didn't give your employer notice and you were supposed to under your contract. What the employer will do about it, well, that's their choice. That's their prerogative. Sometimes employers will actually take issue with it and potentially pursue legal remedies as a result of you not complying with the notice requirements outlined usually in the resignation section of your employment contract. But often employers will not pursue those legal remedies. It really depends on the circumstances, whether the employer believes that there's something, as we say, actionable. There's some damages or some compensation that the employer deserves as a result of you not giving the proper notice. Now, the other aspect of your point letterhead regarding vacation pay, your employer owes you outstanding vacation pay. So it's already an entitlement. If it's been accrued, it's an entitlement of yours, and you should be receiving it. Okay. So if there are issues with that, you also could pursue your options with the Ministry of Labor. So you can contact the Ministry of Labor and tell them about the vacation pay issue that is occurring, and they should be able to help you with that. Alternatively, you can arrange a consultation with our firm. Contact us at help@employmentlawyer.ca. Okay. Lots of questions here. I'm very pleased to see. We have a question on YouTube from Zalika. I might not have pronounced that properly, so I apologize. I was let go yesterday, 18 years of employment with the company. I was offered 8 weeks termination, no severance. Am I owed more? Yes. Contact me right away and we will help you. Again, help@employmentlawyer.ca. You can tell them that you listened to the question and answer session with Jeremy Herman, and I'd be happy to speak with you. Of course, I'll have to review some more details about your employment, if you have an employment contract, etc. But on its face, you are going to be owed more severance, depending on whether that employment contract says that you're not owed more severance. Okay. But absolutely contact us and do not sign anything. Okay. So, many times employers will say, here's a termination offer. You got a day or 2 or 3 to sign it. Well, that's not true. And I have to explain this to people every day. And it's very important that you all understand the deadlines in termination letters. And every termination letter, essentially, there's a deadline. They say that you got to sign this package by a certain date and time. It's a made-up deadline. It's arbitrary. It can be extended, and it doesn't even have to be extended because the employer is just using it as a pressure tactic to get you to accept the severance offer that the employer wants you to accept. But almost always, there's going to be a discrepancy between what the company is offering you upon termination for severance and what you're actually owed. And that's where I come in and my team at our firm to assist people with actually getting the severance pay that they're owed, because almost always when there's a severance offer, it's going to be short of what you're actually owed. Okay, so I hope that helps. And if you have a follow-up, please post it in the chat. Otherwise, go ahead and contact us at help@employmentlawyer.ca. Okay, we have a question from Irmali on Facebook. I left my job March 5th, 2023 for sick leave, applied for disability on April 30th, 2023. Until now, I don't have disability, waiting for an IME, which is an independent medical evaluation. Do I lose disability if I try for modified? Okay, so I'm gonna try to understand your question. So you applied for sick leave. You haven't yet received confirmation that you've been approved, and it could be that you're looking for LTD, long-term disability approval. And if you try to get modified duties with your employer, I think that's what you mean. Yes, I mean you're not going to be able to receive long-term disability benefits if you're working. So if you are working, you don't get those benefits, and you're not going to be approved if you're still waiting. I deal with employment issues predominantly, but we definitely have a great team at our firm who does disability law work. And so you can still contact us and we will arrange a consultation with you with one of our disability lawyers. And you can find out more about this, as you see on the screen, at disabilityrights.ca. And to the extent that there's also employment issues going on, I'm happy to assist you with that. Okay, so either way, you're covered by our firm with both your employment and disability issues. Okay, let's move on. We have a question on YouTube from Ellen. Does the employer have the right to change your schedule after you worked the same schedule for 14 years? And I also have a doctor's note advising not to change my schedule. Okay, very good question. And it does bring us to a new topic that we haven't really discussed today. So Ellen, I appreciate that. And that topic is called a constructive dismissal. A constructive dismissal is where your employer is changing terms of your employment in a significant way and you don't agree to it. So in Ellen's case, that is changing her work schedule. If she has worked at the company for 14 years, she works 9 to 5, for example, Monday to Friday, and now the employer is saying, well, you're going to work 9 to 5, Monday through Thursday, and Friday we can't give you work. Something like that. It could be different things. It could be a change of schedule. It could be that's a change in hours, a change of work days. But the point is that there is a change, and the change is significant, right? If that is occurring, you do not have to accept that. That is a termination of your employment, and you can pursue your severance entitlements, just like you had been terminated by the company outright. Okay. Constructive dismissal cases are very common, where employers are not actually saying you're being let go, but for one reason or another, they got to change your work schedule, like in Ellen's case, or they have to change your pay, or if they have to change your duties or your job location. These are all situations where there is typically a significant change that is occurring, and you do not have to agree to that. There are some minor changes that employers might implement that will not trigger a constructive dismissal case, right? It has to be something substantial, and it also has to be something you have not agreed to. If you agree to a change in your work schedule, and then let's say 2 months later, when you've already been working on that revised schedule, you now say, well, I don't like it anymore. Well, that's going to be a bit of an issue because you've already agreed to it. But if you haven't agreed to it, then there is an issue there, absolutely, and you'll be owed severance pay. Okay, Ellen? So if this is happening to you, then absolutely contact us, arrange a consultation, and we will walk you through this. And we will assist you with getting your severance. Now, you mentioned one other point, Ellen, about a doctor's note. So if there are some medical reasons why you should be working the schedule you're working, then that also can make the issue more severe. If your employer is not just changing the schedule, but also doing so, and it results in some sort of failure to accommodate you, then that is also a human rights issue potentially. And that also gives rise to different kinds of compensation as a result of the human rights violation. Okay, so definitely not something the employer should be doing. Okay, let's move on. We have a question on YouTube from Demonic. If I work a 40-hour job and have a part-time 16-hour job, what severance would I get if I lost my 40-hour job? Would the part-time job affect my entitlements? Great question, and the answer is potentially. So in general, if you're let go from your employment and you're owed severance pay, if you then get a new job or a new source of earnings and you haven't yet finalized what your severance pay will be with the employer, then that new job or that new source of earnings could affect your severance. Now, if in your case, Demonic, you work the 40-hour job and throughout the course of you working that 40-hour job, you also work for another employer, which is what sounds like is happening here. for 16 hours a week, then that is not going to be considered new employment, that 16-hour job, when you get let go from your 40-hour job. So if you're terminated from your 40-hour job, it's new employment or new earnings that would potentially impact your severance pay that is owing to you as a result of the termination from your 40-hour job. If your 16-hour job now becomes a 30-hour job because you got more time available, and so you increase your hours at that other employer, then that increased amount of time that you work for that other employer, that could also impact your severance pay. Okay. But if your 16 hours stays the same, then that's not new. You did that while you were working your 40-hour job. It's not considered new earnings. So very good question. And there are many times where people are going to get a severance package before they find a new job or a new source of earnings. And then even if they find that new job or new source of earnings, after they've locked in a settlement deal or a severance deal, they're going to get that severance deal because they've already finalized it with the employer. Okay. So great question, and definitely something that comes across my desk on a daily basis. Okay. We got lots of great questions today. We have some time left, so I'm going to go through more of them. And if you're joining us now, I'm Jeremy Herman. I'm an employment lawyer at Samfiru, Tumarkin LLP in Toronto, and I'm answering as many employment questions as I can within the time allotted. So don't be shy and ask your questions, and I'll do my best to get to them. So we have a question on Facebook from Rogers. I went on maternity leave in 2021, came back in 2023. My position was eliminated, but I had applied for a temporary position, which I got. The project ends in August, and they're telling me now if I don't get a job within the company, they're letting me go. I'm a full-time employee. I've been there for 9 years. Can they do that, or do they legally have to find me another position within my department? Well, in Ontario, an employer typically can terminate any employee at any time for any reason. There are certain times where an employer cannot terminate you, if you're on a medical leave, potentially, different situations like that. But other than those situations, your employer can let you go so long as they're paying you the appropriate amount of severance. That is what we call a termination without cause. So there may not be a cause, or there might be a cause. It doesn't necessarily matter. The point is that if you're let go, the employer's obligation to provide you severance is triggered. And so the fact that they may not find you another job within the company is not necessarily a legal issue. But the fact that you worked there for 9 years is going to be given a lot of credence, as well as your age and what your position was, in order to calculate how much severance pay you're owed. Okay, and that brings me to an important point, which is that you should always try to find out how much severance pay you're owed, even if you haven't been terminated. Right? You could be an employee who doesn't even expect to necessarily lose their job, but you just want to know what kind of severance entitlements you have in the event that you do lose your job. And so we have an amazing tool for that. And as you see on the screen, the Pocket Employment Lawyer tool. So you go to pocketemploymentlawyer.ca, and then you'll find our severance pay calculator. And the severance pay calculator will ask you some basic questions. Those questions are: what is your age? What is your length of service? What position do you have with the company, or did you have? What kind of compensation are you earning? And then our calculator will immediately determine what range of severance you should be receiving if you are terminated. This is a free and anonymous tool, so use it as much as you want. Tell your friends and family about it. It's a great, great tool to get an idea of what kind of entitlements you have. And many, many people are surprised by what their entitlements are. They're usually more than what you think. So feel free to use that tool. Again, pocketemploymentlawyer.ca, you'll find the severance pay calculator. Okay. We have another question from Alita on YouTube. The employer is moving staff to a new company. On paper, we're now going to be employed by a different company and paid by them, but still doing the same job. Is there anything to be concerned about? Well, yes, potentially. What I've seen in many cases here is that if you're going to keep your job but essentially work for a different company, and that's happening to many of you, what could be occurring is that the new company is going to ask you to sign a new employment contract. If you're being asked to sign a new employment contract, you absolutely want to have that contract reviewed by our firm. I'm happy to do that. I do that for employees all the time. And the reason why is because, first of all, you want to ensure that the new company is going to recognize your length of service with the previous company. You could be someone who worked for a company for 20 years. You're starting with a new company, and the new company says, this is fresh employment. It's as if you're starting from day one. So that you don't want. Absolutely not. You want your tenure to be recognized. Additionally, the employment contract could have all sorts of clauses in there that are not beneficial to you, and that are beneficial to the employer. And one of the key ones is termination clauses, where the employment contract will say how much severance you get upon termination. And so, Alita, in your case, your employer might have not given you, your first employer may not have given you an employment contract, in which case you could be owed a lot of severance. And now your new employer seems like everything is going to be fine and dandy. You got your job, same pay, but there's other provisions in the employment contract that the new employer wants you to sign, which severely diminish your legal entitlements. So absolutely, there are some things that could be concerning about this change of employer to a new company. So I'm happy to have a consultation with you, review your employment contract if you are being offered an employment contract. And if not, we can still discuss what other issues might occur within this transition. We have a little bit of time left, so I'm going to get to Gary Murray's question on YouTube. My employer laid me off this week. I was offered severance, 8 weeks pay in lieu of notice, 10 weeks of severance, an additional offer, which is in the form of salary continuance. Okay, so I don't necessarily see a question here, but Gary, that might be an issue it probably is an issue with how much severance you're owed. It sounds as though you might have worked for the company for about 10 years. So I don't know exactly what the additional offer is. Looks like you got 18 weeks for sure on the table, and some additional offer there. And depending on what that additional offer is, you very, very well might be owed more severance than what they're offering you. So absolutely contact us. You can contact me. You can contact our firm at helpandemploymentlawyer.ca. We'll review your termination documents and other key documents, and we will ensure that you are getting the severance that you're owed in the event that you are not being offered the right amount of severance. Okay. So that will close up for today. Again, I'm Jeremy Herman. We have another employment law question and answer session on Monday with my colleague Luke Serta. So please tune in for that. And it was great being with you, and I'll be back with you guys again soon. Take care.